So we'd like to start our afternoon session. Again, I'm Kim Shepley, Director of the Program in Law and Public Affairs, and this is a conference that's been jointly organized by LAPA, by the Center for Information Technology and Policy, and by the Woodrow Wilson School. I should say also that we're also live streaming this afternoon. So if you ask a question or get involved in the conversation, you may appear on the live stream, and if you object to that, write your question and hand it to somebody who doesn't mind being live streamed. There's also a hashtag. Now for Twitter feeds, now we know, so you can all follow things on Twitter as we go. In fact, this morning there were a lot of Twitterers in the room, so you can also find out what some of your colleagues think as they're sitting next to you. I should say that this, they're laughing over here. So I should say that this has actually been part of a couple of day event. Today is the public day. We also had a workshop day yesterday. We invited several dozen tech and national security law experts to Princeton yesterday to try to brainstorm through, now that we know all this stuff, what do we do about it? What has been done? Is it effective? How can we think about some new strategies? And the reason for doing things in this order was that we wanted to bring some of those insights to you today and to engage you in the conversation about where we go from here, given that what we know about both the surveillance programs in terms of personal privacy and the NSA's programs that have weakened internet security overall, as well as, of course, keeping on the table that government has a legitimate reason to try to protect national security and protect us all from terrorist attacks. So we're going to try to think about how to balance all of those things today. We have three panels. And I should say the tech experts who came yesterday, the law and the tech folks are in the room. And so our format today is going to be that we have folks in the front of the room who will be introduced, very distinguished panels in technology first, then law, then journalism. In each of those cases, the speakers will actually give reasonably short talks, because the idea is to get to an open conversation with the other experts who are sitting among you, as well as those of you who are here. So this is not simply a talking heads conference. This is really meant to be a working conference to think through really what we should be doing. So with that, and because we're running late, we're going to modify the panels a little bit, but we'll have breaks between the panels. There'll be coffee in the room where there was lunch. And so we hope that you'll stick with us for the afternoon. So with that, let me turn over to the moderator of the first panel, Joe Bonneau, who is a fellow at the Electronic Frontier Foundation and also at Stanford. Joe.
Thank you. Right, thanks for the warm intro. Right, so we have three great panelists. I don't want to stand in the way. I'll just start by introducing Matt Green, who's a research professor at Johns Hopkins. If you've recognized Matt, he's prolific on Twitter. He blogs a few thoughts on cryptography engineering. One of the best blogs if you want to learn about crypto, and if you don't want to learn about crypto, you should probably rethink your priorities in life. So Matt's also been very heavily involved in parsing through the Snowden documents. He's worked with The Intercept. He's done a lot of work with the dual EC disaster that he may talk a little bit more about. And with that, I'll turn it over to Matt.
Okay, thanks, Joe. Let me see how close I need to be to this microphone to make it actually work. Is that okay? All right, let's see. Okay. Wonderful. Okay. All right. Oh, no, now I have to hold a microphone. Okay, so I'm a professor of computer science. My specialization is computer security. I work at the Johns Hopkins Information Security Institute, and I mainly work in the field of applied cryptography, which basically means the science of encrypting your data so that it can't be stolen when we store it in different places and when we send it over the wire, which we do all the time. In times you don't even realize how much of your data is flowing over networks right now. The title of this event is Technology, Law, and Policy After Snowden. But in order to give a little bit of context about what that means, I have to talk about technology, at least, before Snowden, at least my field. Before Snowden came along, what I worked on, the applied side of my field, was really just plain computer security, or what people call cyber security, or cyber nowadays. We hate when people say that. What it means is finding ways to secure your data against hackers, against a relatively small number of criminals who are out there somewhere trying to steal your information. And it's a very interesting field. There's fascinating work to be done there, but it's not particularly controversial. There's no political aspect to stopping thieves from stealing your information. So that was what I did before. And people were doing a very good job at fighting us, and we were doing a lousy job at fighting them, but that was the work. Everything changed with the Snowden revelations. With Snowden, we learned things that we had never realized before. We learned things in concrete ways that we had kind of only suspected. One of the things that we learned, for example, is that spy agencies, which we thought already existed and did their work, we referred to them as nation-state actors, were doing a lot more than just, spying on a few targets. There are people in our field who dismiss spy agencies as, spy's gonna spy. But what we learned with Snowden was that people were actually out there performing this mass surveillance of Americans and foreigners' information, collecting this information. So we knew this all in the abstract, but Snowden proved to us that this was actually happening. And before that, really our only interaction with the NSA was sending students there and essentially sending them in that direction and not getting any information back from them about what they were working on. And now we actually knew what they were working on. It was kind of disappointing to us. Okay, so the Snowden revelations, this is before Snowden. The Snowden revelations changed everything for us. It's kind of hard to put into words how meaningful they were for technologists. What I will say is that what we really learned was what we really learned was about the scale and the ubiquity of this kind of surveillance. It's the quantity of it had a quality all of its own. Instead of targeted surveillance, it was this mass surveillance that was changing fundamentally the way the internet worked. So it was really like nothing that had ever been built before. And what was particularly surprising about these revelations from a purely technological point of view was that there was nothing surprising about these revelations from a technological point of view. We knew how this technology worked. We could have built this technology. In fact, we, meaning the industry and academia, in a sense, did build this technology. Because if you look at these revelations, what they are is essentially the content of our research papers just scaled up to this incredible worldwide scale and done in a way that has never been, nobody ever had the cojones to do before, or maybe the lack of constraints to do before. So in a nutshell, what we saw in the Snowden revelations was what would happen if you took all of the attendees of the Usenix Security Academic Conference, locked them in a room with an unlimited budget, and said, you can't come out until you've collected everything. And that's what we got. Okay. So I want to just add one kind of semi-personal detail about this. This is not just me saying, it's not just that I'm saying that they are using our techniques. I know they are using our techniques because I worked a little bit with The Intercept, which is one of the newspapers reporting on the Snowden documents today. And the people who have done raw searches for technical terms in that corpus tell me that when they search for a technical term, it's very hard for them because 90% of what comes up is papers by my academic colleagues and presentations at the Black Hat Security Conference. They have to filter through all this noise of publicly available technical documents before they can get anything that actually tells them about what the National Security Agency is doing. So they are reading. We, unfortunately, are only just starting to read what they're doing, but they've been reading what we're doing. Okay, so one other thing that I want to say about the Snowden documents before I go forward is that we learned as well that the National Security Agency and GCHQ play by different rules than we thought they did. I'm not talking about the scale of surveillance. I'm talking about the way that they work. We've always known that certain types of security technology that we build, like encryption, would stop a surveillance agency from doing its job. And what we thought was that when they encountered encryption, they would use their brilliant mathematicians to find a way around that. When they encountered a roadblock, they would work out how to get through it, get around it. What we learned, and actually it would be helpful if I could advance a slide, skip that one. Let's go, yeah, this is great. What we learned, among other things, is that when they encounter encrypted data, they not only can decrypt that data in ways that we don't fully understand, but they have actually smashed those roadblocks down. And the way they've done it is they've gone and they've sabotaged encryption technologies so that those technologies, which are largely made by US corporations, no longer work. If you can advance a slide or two, I want to show you what this looks like. These are just some examples of the slides, but go forward one more. This is a slide that talks about a project called the SIGINT Enabling Project. This is a slide that talks about a multi-million-dollar operation to essentially tamper with encryption technology made by US manufacturers so it no longer works anymore. This is one of the big revelations to us. We know that you can break encryption technology if you can convince the manufacturers to sabotage it. That's not new. We just never thought that anyone would do this because it makes our security weaker. So that's one of the big surprises here. Okay, so one last thing I want to say, and this is the reason that I'm showing you slides, is that although we've known in the abstract about certain types of surveillance, we've read news articles about warrantless wiretapping, for example. What was different about Snowden was that we now had concrete documents showing us how it was done. And even more than just concrete documents, we had the most mundane possible technology proving to us that it's done, and that is the PowerPoint presentation. There's no way you cannot believe in a technology when you see it in these boring and ugly PowerPoint slides, which is why I wanted to show you these. If you go back one to the happy dance, this one is actually my favorite. This is what happens when you succeed in decrypting things. Okay. So far, what I've talked about is life before Snowden, and I've talked a little bit about life, during Snowden. But what we're actually supposed to be talking about in this panel is technology and life after Snowden. What is this? What is the impact of these revelations? What has it done to us to learn about these things? And the answers to that, there are many different answers. It has had a huge and enduring impact on our field. And by our field, I'm not just talking about academic computer science, which is mostly where I work, but also industry and the open source software community, which is, for better or for worse, where a lot of our security tools come from. And this community has really been energized and, in some sense, radicalized by learning about the Snowden revelations. That's had a huge impact on the way our systems work today. So let me give you a concrete example. Back in early 2013, I would say the majority of Google's and Yahoo's search data, maybe 2012, but the majority of Google and Yahoo's search data was unencrypted, was traveling over at least some wires in a form that anybody who had the ability to tap into those connections could see. And they were seeing it. They were seeing it in huge, huge quantities. I want to go forward 2 slides to show you what those quantities look like. One more. This is a slide that talks about buddy lists and inboxes. If you used an instant messenger piece of software, if you were texting with your friends, chances are every time you log on, your inbox, your buddy list of who you talk to is going to be sent to you. Yahoo was not encrypting that data, so it was being sent to you in the clear over wires that GCHQ and NSA were tapping. How many people's information was being swept up by this? Well, according to this, on a representative day, 500,000 people's buddy lists were being scooped up. So this was surveillance at a huge scale. It was not targeted anti-terrorism surveillance. It was just building a list of who everybody was talking to. What's changed in 2015 is that this data is no longer going over the wire in clear text. It's encrypted ubiquitously. It's encrypted from your web browser to Google. It's encrypted from Google's back end to the servers in Google's data center. It's encrypted between Google's data center. And the same thing for Yahoo and most of these other providers. And most of these changes, which were incredibly expensive and difficult changes to make, were implemented as a result of these Snowden revelations. They were implemented by tech firms who are both angry about this, I mean really personally upset about this, but also by tech firms who are afraid that nobody's going to buy their services if they can't guarantee that they're keeping users' data at least somewhat secure. So that's a major thing. Another thing that's happened in the last few years is that email has at least, which has always been historically a terribly insecure technology, very rarely encrypted, almost as secure as postcards sent through the mail. Email has now begun to be encrypted at fairly large scale. I don't have a slide for that, but you can see the numbers. There's an inflection point, as Jonathan pointed out to me today, that begins with the Snowden revelations and essentially surges upward to a vast majority of email being transmitted in a secure fashion. One last area of technology that's really begun to develop is the area of purely end-to-end encrypted messaging. And what's different about end-to-end messaging is that instead of relying on Google to simply secure our messages as they go over the wire, with end-to-end technology, I can send a message to you without anybody, including my provider, including Google or Apple, being able to tap into it. And that has a major impact on both programs like PRISM, which we know to be surveillance programs that actually tap directly into servers in the back end of providers like Google and Apple. But it also has an impact on law enforcement, which no longer has a way to issue subpoenas, for example, and get the clear text of your text messages if you use something like Apple iMessage. So these changes have actually taken us, they've closed many of the gross vulnerabilities we knew about that the NSA was exploiting, but they've taken us a step beyond to actually a world that is even more, in a sense, secure, or at least difficult to wiretap or surveil than the world we used to live in. And this change is accelerating. It has, there's a lot going on. There are a lot of people very energized. Those changes might have happened eventually anyway, but they happened quickly, and people made those changes because of Snowden. Okay, so I want to leave this panel, or at least lead this panel, with a few basic questions. And I'm not going to try to answer them, but I want Jonathan and Ross to take a crack at some of them. When we spoke with Snowden, one of the discussions that came up, I think was very relevant, is do we as technologists have an ethical obligation to fight this kind of mass surveillance? Is it something that we should be thinking about? Is it something, should there be a Hippocratic oath for people who work in this industry? Should we be trying to at least do no harm, and maybe at best try to do something to counteract this? So that's one issue. Another issue is, are there certain debates that are going on in Washington, D.C. today that actually have the potential to put us very far behind where we were before Snowden. One of those is that there is a new proposal on the table to perform information sharing. It would actually allow businesses to share customer information with the intelligence agencies. We don't know what that customer information is. It could be anything from your email to your search history to when you accessed Google. These kind of information sharing capabilities could protect us in some ways. They could allow the government to detect cyber attacks, but they could also open the door to surveillance capabilities that weren't even capable in the era when Snowden worked at the NSA. The other major political issue on the table right now is whether or not these encryption technologies should be regulated. So because of these end-to-end encryption technologies I mentioned, law enforcement is terrified that they're going to lose the ability to wiretap us and to be able to solve crimes by going out and saying, I want to know all of the messages that went from this phone number to this other phone number. There are actually proposals today to say that those technologies should be regulated, maybe banned, or maybe limited in ways so that the government will actually be able to surveil them. These are major questions facing us. They're going to fundamentally change our entire industry. How those policy debates come out in Washington will have huge impacts to what people are doing out in Silicon Valley. And so these are the big questions facing us today. And I guess, the overall summary of this is, should we as technologists be fighting? Should we be taking on the role that our policy colleagues, no offense to all of you guys, have kind of, if you guys fail in Washington, D.C. to limit these surveillance capabilities, should it be our role as technologists to fight them? And what should we be doing? How hard should we be fighting? Are we the last line, or is that actually going to make us less secure in this world? So I'm going to turn over to Ross to talk a bit about the ethical obligations of security research and of technologists in general. Thank you.
So I'll just step in to quickly introduce Ross. Ross Anderson is a professor of security engineering at the University of Cambridge in the UK. I can honestly say I've probably learned more from Ross about cryptography and security engineering than anybody else. He was my PhD supervisor, so it would be a shame if that wasn't the case. Although Ross wrote the textbook Security Engineering, so he's literally written the book on how to engineer secure systems. He also, like Matt, he also blogs at Light Blue Touch Paper. In fact, he blogged today about with some notes from the conversation we had with Snowden yesterday. So if you aren't familiar with Ross's work, he's a veteran of the crypto wars of the 90s, so he's seen a lot of these debates the last time, the last time they were cool. And he's really worked in cryptography. He's pioneered the field of security economics, so really one of the world experts in a really broad range of security topics. Ross.
Well, thanks, Joe. Joe asked me to talk about ethics here, and over the last 18 months, I was involved in a project with the Nuffield Bioethics Council to look at what happens to medical ethics in a world of cloud-based medical records and pervasive genomics. What's the relationship of this to Snowden, you might ask? Well, it's not just state surveillance that is changing the privacy frontier. It's the fact that lots of information is now being centralized that used to be distributed. Medicine's a good example of this. Your medical records used to sit in a PC in your doctor's office. and now they may sit in a server farm that's rented out by your insurance company. And so what sort of implications does this have? Well, we ended up producing some ethical guidelines for medical researchers that I think go straight across to people who are doing research in security. So the kind of problem you have to deal with is the fact that not everything that is lawful is something that doctors or medical researchers should do. If doctors were to do anything that wouldn't actually get them thrown in jail, then we wouldn't trust them with our bodies, let alone with our secrets. Because there are such things as moral values and interests, and in particular, if you reveal to somebody something that's very personal and sensitive, an embarrassing disease, a relationship issue or whatever, then you've got every right to expect that it remains private. So this is perhaps one of the touchstone issues. If things will work for medicine, they may very well work for other applications as well. Things are made more complex in that you don't just have the stuff that you tell your doctor. There's the stuff that your Fitbit measures. There's the stuff that your health insurer may scoop up from social networking systems. There's all sorts of things may contribute information about you. And in fact, a colleague of ours at Cambridge, Michael Kochanski, did some analysis of people's behavior on Facebook, and he observed, he measured, for example, how many Facebook likes it took to sort people into different categories. Anybody got any idea how many Facebook likes it takes to tell whether you're straight or gay? 4. Right? That's the sort of information that people are disclosing heedlessly in fora that they think may be slightly private, but that aren't really. So how do you cope with this? The suggestions that we come up with, and there's a big report on this, which we spent 18 months on, me, ethicists, medics, people from the insurance industry, and so on. I tell you, we had some pretty hard arguments before we come up with something we all agreed with. Come down to 4 principles. The first principle, which is really the key one, is respect for persons. A lot of people in the health IT business see data as an industrial raw material, just as the NSA sees all our personal data as an industrial raw material for intelligence processing. In the health context, that's not right, because information comes from people who handed it over in confidence to their doctors. And you've got to recognize that people have got profound moral interests in controlling others' access to and disclosure of information that they have handed over in confidence. Now, if you start off from that as an entry point into this debate, then you'll probably end up going to roughly the right places. But if you start off thinking of data as an industrial raw material, then I think you're lost before you start. The second principle that we come up with was human rights, because modern societies are machines in which some wheels move faster than others, and nations move their constitutional wheels deliberately very much more slowly than others. You don't want to change the constitution in the months after 9/11, and constitutions are designed so that that can't be done. So the next principle is that the set of expectations about how data will be used should be determined with regard to established human rights. And if it's inconvenient for your business model that the Fourth Amendment, for example, gets in the way, then there's something wrong with your business model, right? That's something that should apply to national intelligence and law enforcement agencies, as well as to health IT entrepreneurs. And in the UK and in Europe, in fact, we got a lot of health IT bodies are trying to cut corners on established European privacy law. The third principle that we come up with is participation. Now, in an old-fashioned medical environment, if your doctor wants you to take part in a clinical trial, he'll ask you. Nowadays, in a world of data, it may be less interactive. There may be a notice up saying we may use some of your data for research. If you're not comfortable with this, please speak to your doctor. But there's got to be the consultation. And there's got to be a consultation that's fair and reasonable, that doesn't just take into account 99% of the drug company's interests and 1% of the hunter's interests. And you basically have to take into account everyone who's got morally relevant interests. Again, this is highly relevant to law enforcement and national intelligence, particularly the operations of law enforcement and national intelligence within states that are at least reasonably well governed. You know, you may have to think a little bit harder about what you do with places like Somalia, which don't have a government, but certainly, surely between countries like, for example, America, Britain, Italy, Brazil, India, and so on, there should be civilized ways of operating where people have got a reasonable expectation that they'll know what happens to their stuff when they put it on the wire. That's one of the great changes that Snowden has brought across, that things that were vaguely known by or suspected by people like us are now basically known to all. So well done, Edward, for bringing participation in national intelligence decision-making. And the fourth principle is accounting for decisions, in that if you're going to use people's data, there have got to be effective systems of governance and accountability so that people know what you've done with their data, and you tell them even if there is a security breach. Now, it's great that America brought in security breach disclosure laws. Most other countries still don't have them. And so if a laptop containing 8 million people's medical records goes walkies, as happened a few years ago in London, then in Britain, we don't have any right to be told. And again, this is something in which America leads the world. So that's the first aspect of ethics, what happens as a result of stuff being collated together, quite lawfully, but in ways that create new dynamics around pressures for access to information. Now, the second thing that I want to turn on is what happens in commercial wiretapping and commercial espionage and data collection. Now, there's an interesting case here, case of a company called Farm. Farm is a behavioral advertising company which several years ago set up in business in the UK, and their business model was that they would wiretap your link from your ISP. They made an agreement with BT, which is Britain's biggest ISP, that they'd wiretap everybody's traffic, and they'd use deep packet inspection technology, just like GCHQ does, using DPI boxes sitting in BT's data centers, just like GCHQ's boxes. And they would then sell this to the advertisers in competition with Google. So an advertiser who wanted to know what Matt was interested in could go to Farm and could basically buy a wiretap trace or, advertising stuff that was derived from that, rather than, for example, going to DoubleClick and paying Mr. Google to know what Matthew was interested in. And that meant that when Matthew visits a website, they can display appropriate ads. Now, the fascinating thing here was that it was the behavior of companies like Farm which also started to drive companies like Google and Yahoo to encrypt their search traffic and data streams. Because if you're Google, you don't want Farm stealing your breakfast, and thus made the NSA's life harder. Now, the beautiful thing here is that when Farm set up in business, they went to our Home Office, our equivalent of the Department of Justice, and they said, this is what we're planning to do. Is it legal? The Home Office, being stupid, said yes. Farm had a former cabinet minister on their board of directors, so the Home Office didn't want to face them down. And an NGO that I chair then took up cudgels and persuaded the Home Office that in fact Farm were conducting unlawful wiretapping against our Interception of Communications Act and Regulation of Investigatory Powers Act. And eventually the regulatory cudgels were pulled out and Farm were stopped from operating this business model in the UK. But there's something to think about, that the Home Office thought they were being nice to a company of a former cabinet minister by letting him do unlawful wiretapping. And because of that unlawful wiretapping, sources of intelligence on which they used to rely have gone dark. So if there is a legal solution to the going dark problem, it's perhaps not the regulation of cryptography, it's perhaps the regulation of wiretapping. It is perhaps the vigorous enforcement against companies of the laws that most countries have against doing wiretapping without a warrant. But of course, nobody thought about that at the time. And I suppose the final lesson to be drawn from that is that if you're a government and you're trying to regulate around things like wiretapping and encryption, you just have to be very careful and cautious about what you do, because actions that seem innocuous at the time can have some very, very strange, unpredictable, and for governments undesired side effects.
Okay, so with that, I'll introduce our third panelist, Jonathan Mayer. So Jonathan is a lecturer now at Stanford Law School, a graduate of Stanford Law School, and he's also in the very unique position of being a PhD candidate in Stanford at the computer science department. So he took the very innovative career path of enrolling in law school and a computer science PhD at the same time. And that puts him in a really great position to comment both from the tech and the policy side on these issues, which he's been doing. He's been teaching a course on Coursera, an online course on surveillance law, as well as also blogging at Web Policy is the name of his blog. So a very unique perspective from both sides. I'll turn it to Jonathan.
Thanks, Joe. I'm glad Ross covered the morality issues, since in law we're kind of like professionally forbidden from being moral. So I want to talk quickly about high-level responses to government surveillance. Specifically, should we look to law or technology as the right response? Then I want to talk a little bit about computer science ethics. Again, not too much because of my own professional ethics. And then last, I want to take head on this crypto backdoors issue, or going dark. That's been a recent problem here in the States. So starting with high-level responses to government surveillance. There's a particular view that I think has gained a lot of traction among technical experts, and I think there were some hints of it this morning, that the law doesn't matter, or doesn't matter too much. And really, technology is where we have to look for preventing surveillance. And the consequence is we need pervasive encryption. I completely agree that pervasive encryption is good policy, and it's a really effective tool for protecting against criminals and less legitimate governments. Where I part ways with that view is on the law. The law does matter. I think unambiguously the NSA does follow legal rules. That's my experience from visiting Fort Meade. That's my experience from looking at some of the unredacted Snowden documents. That's my experience from talking to attorneys at the Department of Justice who work on regulating the NSA. There is incredibly scrupulous rule following. And there was a period of about 5 years after September 11th where the Department of Justice kind of winged it, but then things cracked down quite a bit. And there's even court oversight of domestic programs. So I don't think the problem is rule breaking. I think the problem is that the rules themselves are deeply broken. For instance, drawing this distinction between metadata and content that doesn't have much grounding in policy anymore. Drawing this distinction between international data and purely domestic data, which doesn't have much grounding in policy anymore. This notion of targeted surveillance, even at mass scale, being okay so long as the target is acceptable, and incidental collection at mass scale being that is necessarily consequent from that targeted collection being okay. That targeted versus incidental collection distinction also not making a lot of sense anymore. So I think the big legal question is, how do we fix the law? If there is rule following, but the rules are broken, how do we stop the rules from being broken? And I think the answer in part has to be that computer scientists have to do a way better job of informing policymakers and the judiciary. The community of technology experts is like astonishingly bad at that. And I think there's a great need to take policy and law very seriously as fields of kind of intellectual endeavor, and also as areas where influence requires a concerted and professional effort. So for instance, I think there is a great need to send computer scientists marching over to the White House and Capitol Hill explaining issues, writing amicus briefs and doing regulatory filings, and perhaps most importantly, doing empirical research that's directly responsive to open questions and open problems in law and policy. Computer scientists have a lot to say about shortcomings in the status quo, and right now we're just not very effective at addressing them. So that's my quick sales pitch on why the law matters and what computer scientists and other technical experts should do about it. Now on to that little bit about ethics. And that is, this morning Edward Snowden suggested that many employees in the intelligence community are deeply unsettled by the practices of that community. And my own experience interacting with employees in the intelligence community is not consistent. The experience I've had is that intelligence employees deeply believe in their agency's mission and believe in following the rules and upholding the rule of law. The problem that I have experienced most often is a quite uncritical acceptance of the rules that govern intelligence. And the general mode seems to be, well, the lawyers said it was okay, and so that's all right. But of course, law isn't created in a vacuum, and good surveillance law requires good technical understanding. There's this sort of triumphant pronouncement from time to time that it's legal is a floor, not a ceiling. And the intelligence community now appreciates just because they could legally do something, that's maybe not enough. But there's, I think, a lot of follow-up that needs to be done there. Just because there is a legal argument for a program, and maybe that's not enough, there's more to be said. Why was it ruled legal in the first place? Who decided it's legal? For instance, according to some recent declassified material obtained by the New York Times, the Department of Justice very consciously shifted from a position of, are we articulating the best view of the law when determining the legality of NSA programs, to we are going to come up with credible legal interpretations that support what the agency is doing. That's a very different mode of legal analysis, and it's important to recognize the distinction. And last but not least, were the decision makers fully informed? It's now very clear from leaked and declassified documents that the Department of Justice and the FISA court did not have a full appreciation of how certain surveillance programs worked. And so I think it's important for technical experts within the intelligence community to make sure that the decision makers who are setting out the rules are fully informed so the rules don't get broken in the first place. Okay, so that's my thinking on ethics, such as it is. And last but not least, this backdoor issue that's playing out in Washington right now. So the government calls it the going dark problem. Computer scientists have like a bunch of terms for it in the field, most of which are like totally inappropriate for this audience. The newest one from Representative Ted Lieu at a House hearing on Wednesday was, I thought this was great, technologically stupid. So I think there are a bunch of reasons why encryption shouldn't come with mandatory backdoors. One that Edward Snowden articulated earlier today, they seem to be unnecessary. In fact, the data doesn't support that there's a problem with government access being frustrated by encryption. There aren't good anecdotes suggesting the government has been frustrated. In fact, every single anecdote that's been trotted out suggesting encryption has frustrated an investigation has fallen apart under scrutiny. So there's unnecessary in fact, also unnecessary in theory. As Snowden again mentioned this morning, government access remains the default for popular devices because of cloud backup. So even if the physical device itself is encrypted, you can still go serve a warrant on Apple or Google and get the data. There are also great security risks. A very recent example of this was an attack on SSL, communications security protocol called Freak. This like trended naming is great. The Freak attack worked because of some compromises in encryption made in the 1990s. Right? So there was a legacy of a couple decades ago making an attempt to add a government backdoor, and decades later it bit us. So, not hypothetical security risks that are already problematic. There's this issue that backdoors wouldn't stop with the United States. China and Russia and so on would demand the same capabilities. There is this issue that they're trivial to circumvent, right? You can just download an end-to-end secure messaging app. If Apple backdoors iMessage, go download something that's like, I guess it couldn't exactly be iMessage because of trademark, but anyway, come up with some spin-off of the iMessage name, but it happens to be end-to-end secure, and there you go. And so in the end, you have to believe that there's some criminal who is smart enough to twiddle all of the defaults for device backup, make sure their device is locked, doesn't fall into government custody, make sure to turn off any sort of data backup for individual apps that hold incriminating information. That criminal is smart enough to do all of that, but not smart enough to download a security app from the App Store. And it's very difficult to believe that class of criminals is particularly large. So I end where Representative Lieu did, that I think backdoors are stupid. That's my piece.
Cheers to that. Well, I'll just shop for a second. So we'll have some. You can talk. Excellent. So we'll have some time for questions. There was really a lot there between the ethics and the technology and the morals. The ethics and the law and the technology. I'll try to start it off with a sort of simple question. I'm of the opinion that backdoors are bad and mass surveillance is bad. Both fixing the law and fixing the technology are pretty slow. If we take it as our goal that we want to make it hard for mass surveillance to happen, do we think what do we think is just the most efficient use of resources? Changing the laws and having this years-long process of reform and changing the norms of the intelligence community, or the years-long process of upgrading everybody's encryption, getting HTTPS everywhere, getting everybody to use end-to-end communication. What do you see as being the most promising thing in the short term to push on?
Have any of these laws actually passed, the reform laws? Have any of the reform laws actually gotten close to passing? I guess that's the first question.
Well, I think we can agree both of these things are really on the order of years in the best case, right?
We've had bills up in front of Congress though that failed. It wasn't that they were being debated for years. They went up in front of Congress and were shot down.
So
There's one that's about to be, only one paragraph.
Okay.
Why don't you talk about the one that's about to be passed?
So there's a legislation pending before Congress now, the USA Freedom Act, that would, among other things, eliminate the bulk domestic telephone metadata program that's been very controversial. And it appears to have decent odds of passage. It's always difficult to read the tea leaves on these things. The reason I think that particular debate has kind of taken so much time and now is playing out much more quickly is there's just a critical deadline in U.S. law. June 1st, the statute that that program is operated under will expire, and the White House has said they won't seek to reauthorize the program on an alternative legal theory. There are alternative legal theories, but they've said they're not going to. And so it sort of has the task expands to fit the time allotted quality to it.
Does this cover other kinds of electronic surveillance, like email and text messages, or only phone data?
So this legislation, the cracking down on authority, is only going to be bulk surveillance under Section 215. So the very controversial programs involving internet traffic, where one end is foreign, or involving email, other data stored in the cloud, where the owner of the account is a foreigner outside the United States, or all of the stuff that goes on overseas. That's not going to be changed by this legislation. So it's very, very much incremental.
Domestic traffic data, in other words.
Known domestic traffic.
Talking to the microphones.
Yeah.
So basically, you're saying phone records where we can guarantee based on the phone number that both records are both ends are in the U.S.
It's not just phone records. Sorry, I was handed a mic. It's not just phone records. It's business records under either 215 or pen register trap and trace or national security letters. So it's still just the metadata essentially. But it would cover internet metadata under those. It would limit the bulk collection. If some people say and some people say limit the bulk collection of internet metadata under those authorities.
Okay.
They're different standards, right?
Well, it may be of interest that last year the European Court of Justice shot down the Data Retention Directive, and the British government put through a bill with a sunset clause at the end of next year, which also covers domestic communications data. So as soon as our election is over next week, we're going to be involved in a tussle with the spooks, police, and other assorted actors, trying to get a law drafted this summer, which will give them what they want in terms of communications data. And they want an awful lot more than I think has been discussed here so far. They want the right to be able to run their own software on Mr. Google servers and Mr. Facebook servers and so on, so that they can do things like snowball searches and covert community detection and so on, where the traffic data is actually held. And mark my words, if they get away with it in Britain, they'll be coming to a congress near you real soon now.
Yeah. I'm going to stand up. Kim Shepley again from Princeton. Yesterday in our tech workshop, one of the things that we discussed was a proposal that has gotten a fair amount of support in the United States that has to do with encryption keys and where they're held and who has access to them. And Matt in particular did a great explanation for our group yesterday about how these work. And I wonder if it might be possible to say something about what this proposal is to basically work through a sort of technological safeguard, legally regulated, for ensuring privacy of communications across devices.
So the 1-minute summary of what we discussed yesterday is that there are two different kinds of encryption technology. There are technologies that protect your information as they go to your provider, but your provider has access to your information. So Facebook is a great example of that. Facebook can see all of your posts, even if you say that they're private. Or the other kind of technology, which is end-to-end in nature. So Apple iMessage is a great example. You have a key on your phone which never leaves your phone. The data is encrypted only to the recipient who you've targeted to be the actual recipient. Apple claims they can't read your messages, and they've built a system where essentially they've thrown the steering wheel out of the car. So they can't, no matter what the government tells them to do, they're limited in what they can access. These are the two kind of paradigms for encryption right now. The third paradigm, which is being proposed by Congress, is that Apple should modify their encryption so that now a copy of every message will be encrypted under a key belonging to the US government, or maybe belonging to some pair of government agencies. And this would actually change the dynamic. Now Apple would not have access to the information, but the US government would essentially have a backdoor in every iMessage. And so this is the going dark, this is the Encryption Backdoors proposal. That's the technology at issue. It requires major changes to the way technology works, and it's a very complex debate.
Well, and we were around this circuit in the 1990s when I was involved also in the debate, and it falls apart at a number of hurdles, one of which is jurisdiction. There's more than one country in the world, and Apple makes most of its sales overseas. And if you demand that the phone has got a backdoor for the FBI, then the Russians will demand a backdoor for the FSB, and the Chinese for the People's Security Police, and so on and so forth. So how do you deal with that? You end up having very complicated mechanisms to decide which country the phone is in and which country the person owning it is from, and so what sort of police keys should be installed at the moment. And if I'm sitting here in America and I use an Apple product to speak to my uncle who's in Australia, for example, then which country's secret policeman should have access to the keys? Once you think about what's involved in building all this stuff, and the implications for the integrity of products, for the difficulty of registering products, for the credibility of the companies that sell them, for their vulnerability to competition from companies overseas that don't labor under similar legislation, and so on and so forth. And then a sensible person will take a deep breath and say, look, forget it.
Yeah. Actually, people should introduce themselves, because they're very impressive.
Okay. I'm Margot Schlanger. I teach law at the University of Michigan.
You should say what your current job is.
Okay, and I used to run the Office for Civil Rights and Civil Liberties at the U.S. Department of Homeland Security. And I guess my question is, it's not so much a question as just a plea, that when we talk about this stuff, we remember that we're not only talking about foreign intelligence, and we're not only talking about the NSA. When the government gets all anxious about encryption, the reason they're so anxious isn't only about intelligence. They're also very anxious because of regular old criminal law enforcement. And we will do better in proposing policy solutions and in talking about what those concerns are if we remember that they're not only interested in, spies or nefarious terrorists or people who they think might possibly, have a connection to such people, but drug dealers and child pornographers and the like. And that it's possible that doesn't change the policy outcome, but if we're not having a conversation that includes all of that stuff, then we're not actually answering what the government's issue is, which is that they're worried when they get regular old warrants, where you go to an Article 3 judge and you apply in a way that's like, that they're not going to be able to get that material anymore because the drug dealers are going to be encrypted. And so I don't mean that I don't mean to say that necessarily changes things, but I really think that if we don't remember that this particular part of the conversation is both, that we're not going to end up having an effective policy conversation.
So I just want to say the only problem with this argument is that there is
Wait,
no...
I didn't just make an
No,
argument.
I'm sorry, but the argument in general is that there's really no technology system that can resist intelligence agency surveillance that doesn't also have the effect of locking out local police. And there's just no way to square that circle.
Yeah, no, I think that's right. So that you have to remember that when you say I'm distrustful of the NSA, you're also saying I think it's okay that drug dealers can't be surveilled, and maybe that's fine. Like it used to be that drug dealers actually, talked to people on street corners, and that meant that the folks who were interested in them couldn't know every person they'd spoken to, and maybe that's fine. But you just have to remember you're talking about both.
Well, there's also the bigger picture that when people in government talk about going dark, we technologists really are not very impressed at all. Because over the past 30 years or so, we've so hugely changed the world that from law enforcement's point of view, it's 20 steps forward and 1 step backwards. Just think of it this way. 15 years ago, if you wanted to follow a suspect, that would cost you $10,000 a day, right? Because you need to have 20 or 30 officers and 5 cars and radios and all the rest of it. Nowadays, it's completely trivial. You go to their mobile phone company and you get a location trace on their mobile phone. There's so much available that for law enforcement to complain that there are 1 or 2 little gaps in the coverage that in an ideal world they would also like to fill is counterproductive. Now, speaking to senior police officers, it's now the case in Britain, for example, that 90% of really serious crimes of violence, murders, robberies, and rapes, are solved with the assistance of traffic data. Things like mobile phone location traces. These are not affected by this at all. It is not feasible. It's possible to build anonymous mobile phones that have location privacy, but you'd have to completely rebuild the whole world infrastructure to do it. So as a practical matter, that's not going to happen. The stuff that is of enormous value to police, knowing who was where and when, and who traveled with whom on which bus, and who was standing next to whom at the bus stop when the subject was knifed, that's something that we've provided and something that will be with us for the foreseeable future.
So hi, I'm Matt Olsen. I was the director at the National Counterterrorism Center, and I was general counsel at the NSA. I want to ask Jonathan a question. I generally agree with your key points, and I mean, it may sound quite self-serving, but I do think that people at the NSA tried to follow the law, where, as you pointed out, but I also agree that in some ways the legal rules have a hard time keeping up with some of the changes underlying how those rules are put in place. In other words, the problem. The difference between metadata and content, and how that plays out, and how the law tends to lag behind. And your point about that computer scientists and technologists have a lot to add to this debate, but you said they're not very effective. So here's my question, which is, and you're at Stanford. So what I've found in trying to interact with the technology community is not just not being effective, but actually a lack of interest or a lack of desire, and a lack of from the companies, at least from their own interests standpoint, don't see a value proposition in interacting with the government right now. So I think that one of the challenges is how to bridge that gap, how to enlist the technologists, the computer scientists in this debate in a way that will help inform the policies, that will help keep the law up to date, in a way that will allow NSA to continue to follow the law, because I think that's a real challenge.
So I want to take that in 2 parts. The first is the relationship between the tech sector and the government, and then how the tech sector and individual experts can work to inform policymaking processes. The relationship with the government is really bad right now. Stanford hosted the president and the secretary of defense. Both meetings had some significant omissions in private sector attendance, and they were in no small measure real pleased, saying, look, we have a lot we need from each other. We need to work together. And on the Silicon Valley side, unambiguously, there was just deep hatred for what the intelligence community has done. I mean, deep, visceral, we really loathe those guys. It's going to take a long time to get over some of what was disclosed. I don't have a good answer on that. I understand where it comes from. I think if I worked at one of the companies that was revealed to have been compromised, I would probably be really unhappy too. That's not going to go away. As for individual experts or companies making a concerted effort to facilitate individual experts informing senior policymakers, there I think there is a lot of room for improvement. The traditional model for education, for work in professional computer security research has sort of been, you point to like the real world and policy and so on as like this interesting thing that then motivates the math research you wanted to do on the more theory side, or on the on what passes for applied very often. Sort of, here's something we built in a lab that might one day have real world applicability. And kind of closing that gap between the real world and where the intellectual forefront is, I think is doable, but there's a lot of room to go. I think it's going to involve close collaboration between lawyers who are more technically sophisticated than the average lawyer and computer scientists who are more legally sophisticated than them. And thankfully, I think there are some promising signs. For instance, in some of the impact litigation against the NSA, there has been greater involvement, both behind the scenes and in actual briefing, by real computer scientists than there has historically been in a lot of litigation in this space. And policy making in this space. While again, there's a lot of room to go. For instance, there is not a single computer scientist on the Privacy and Civil Liberties Oversight Board, nor is there a single computer scientist on the President's Intelligence Review Group. That said, they talked to computer scientists, they heard, they received written comments, they received, in the case of PCLOB, some testimony. So the amount of technical input and the quality of the technical input is definitely coming a long way.
Well, if you go back 10 or 15 years, you used to see NSA people coming to industry conferences, crypto, Eurocrypt, and so on. Since 9/11, we've not seen these guys. What we've also seen is a drifting apart in cultures. For example, Peter Swire, who was one of the people the president asked to look into the Snowden revelations, remarked to me that the thing that struck him with great force is that when he spoke about Snowden to people on the West Coast, everybody thought he was a hero. And when he spoke to people on the East Coast, everybody thought he was a traitor. A thing that I've noticed as someone who does security economics is that people on the West Coast think of the world in terms of network externalities. That's the economic model people use. You build a system and you get millions of users and then you figure out a way to monetize it later. Whereas people on the East Coast thinking of economics in terms of nations have a certain taxation capacity which they can use to build a certain number of aircraft carriers, and that's what power is about. It's a completely different, almost 19th century view of economics. And you see this cultural gap arising and in fact widening at all sorts of levels. It's probably because of the fact that our industry has been moving ever more rapidly over the past 20 years while government's been staying still. And when we look, for example, at IT in government, we see ever more IT projects in government failing because government fails to have, even in ordinary civilian departments like Department of Health and Human Services, there are insufficiently good, many good systems engineers there to make sure that, for example, the Obamacare website is delivered on time. So there's a much bigger problem here of the gap between government on the one hand and technology on the other, of which the specific problems that Jonathan's been talking about are only a microcosm.
So I'd like to ask a follow-up question, actually, kind of tying back to thank you. Kind of tying back to what you were talking about earlier, Ross, comparing your work in ethics in medicine and health records to surveillance. And Jonathan said there aren't any computer scientists on the Civil Liberties Board. We don't even have a really good definition of what a computer scientist is, though. We don't have cards that we carry around. Somebody like Snowden himself was not really a classically trained computer scientist or cryptographer, as he's pointed out. And we certainly don't have any notion of, if for something like medical ethics, you would trust that the doctors on there would be looking after patient welfare and would sort of be, ethical guardians. Whereas in this case, we have technically minded people, both for the NSA and, imagine that we could put one of you on the Civil Liberties Board to advocate on behalf of crypto and users, right? Certainly, we don't have a standard ethics. So, how would we try to mandate or ensure that there really is a voice of crypto who's trained and who understands the technology?
I think I'd be quite happy if you could get one capable IT guy in every government department at a senior level, so that when policy is being made, when ministers are sitting around the table with first and second level civil servants, there was somebody there who actually had a clue about systems.
So
that would be an enormous start.
That sounds fantastic, but how do we write in the notion of has a clue? I know it when I see it? I certainly know lack of clue when I see it.
I know it when I see it, and I know its absence when I see that too.
I actually want to go back to the issue of law enforcement and lawyers and working with technologists. Sorry? Introduce yourself. Oh, I'm Erin Clark. I'm a member of the Tor Project, and I also work as the security engineer at First Look Media and with The Intercept. I have to say that from a technical perspective, I'm not interested in helping law enforcement capture petty criminals. If I'm going to work with lawyers, I would rather have them focus on criminals in like the upper levels of the NSA who are twisting and bending the law and misusing technology. So it's just more of a comment for my other technical people. If you're going to use your skills, perhaps that's a better use.
But should we have backdoors in their phones?
Didn't we get that 2 years ago?
Well, I mean, if they want that much transparency, I don't feel it should be in one direction.
So I'm Kate Martin. I'm the director of the Center for National Security Studies in Washington, which is a civil liberties organization. I've worked on these issues for a long time. And I guess I would just want to say to the tech community that government service is public service, and to say that the way to get a high-level, very good IT guy in every government agency is for you guys to come work for the government. And yeah.
Well, I don't mean to interrupt, but that thing you just did right there, that is one of the very problems we have as a technical community. We are not IT guys.
I
don't mean that to be.
Excuse me. I think I was just using Ross's phrase, but
this is actually at the core of the problem, because if I had wanted to end up my career as director of GCHQ, then I should never have done a degree in math or computer science. I should have had to do a degree in something like Russian or Chinese, because in public service we are seen as IT guys. Right, we're like the guys in the banks who carry big sacks of coins around. Right, we're the hired help. We are not gentlemen. We are other ranks, and that is a problem. Nobody who is a self-respecting person with a first-class honours degree in computer science would dream of working for the bloody civil service, because you're treated like a black man on a bloody plantation. Right, you never get to gamble away the winnings on the riverboat.
Okay.
I think our democracy requires people who care about public service to do their best to understand and join and converse with and debate with the people inside the government who are also committed to the public good. There are many people inside the government who aren't, and there are many people inside the government who are committed to the public good. And I think that we need the conversation, and we need your participation as technical experts. Does that phrase do it for you?
I think...
Well, my friend Julian Huppert, who does actually get it and worked in the next lab along, is now the MP for Cambridge. The only problem is he's the only member of Parliament, member of the House of Commons, who actually knows how to program out of 650 MPs, right? And we've got one member of the House of Lords who also knows how to program, but he got into the House of Lords because his ancestor was a drinking buddy of King Alexander III.
So I used to be more on the kick of like who's got training in computer science or computer engineering in Congress or in Washington circles until I haven't actually verified this myself, but someone told me Herman Cain has a master's in some sort of computer science or computer. If that's right, I'm just going to go ahead and not stand by that.
But he's not in Congress.
He's not present. Right. But anyway, I wanted to make sure to clearly distinguish between IT and computer science, not singling Kate out, for some real progress that has been made recently. So there's an organization called the U.S. Digital Service that's done great work, another organization called 18F that's done great work trying to secure federal IT infrastructure, make it easier to use, bring it up to best practices from Silicon Valley. I think they're exceptional organizations, and absolutely folks who are willing to sacrifice a little salary, sacrifice a little location. It's great work. That said, USDS, AT&F, they don't track directly into any sort of senior policymaking position. I mean, they help build websites and technical infrastructure. They don't get to be in the room when you figure out what the surveillance program looks like or how it changes or so on. And right now, that pathway just doesn't exist in Washington.
So on that note, unfortunately, we're going to have to wrap up here. Yeah, we'll have a sketch. But let's just first thank our panelists. That was great.
So let me tell you what's coming up. So as you've seen from some of the people who have identified themselves, we have a lot of experts in the room, a lot who haven't yet identified themselves, but who will in subsequent panels. We're going to take a brief coffee break, 10 minutes only, and come back because we're going to try to get on track. Let me tell you what's in store. So our next panel is called Protecting Security and Privacy. And our lead speaker is the Honorable Patricia Wald, who is the former Chief Judge of the D.C. Circuit Court of Appeals and who is actually now a member of the Privacy and Civil Liberties Oversight Board. And the other commentators on that panel are Ben Weisner from the ACLU, who in addition to being Snowden's lawyer, is also the director of the Speech, Privacy, and Technology Project, Richard Salgado, Director of Information Security and Law Enforcement Matters for Google, and me. And then we have a third panel this afternoon after that one called Reporting National Security Secrets, in which the panelists are Bart Gellman, whom you heard this morning, but he gets to speak in his own voice, Matt Olsen, who is former director of the National Counterterrorism Center, and Karen Kaiser, who's senior vice president and general counsel of the Associated Press. So I just wanted to tell you, we have incredible expertise in the room, so don't take coffee and wander off, please. Go for coffee, come back, and let's participate in the conversation. 10 minutes, please.